My name is William Bill Ballas. I'm an attorney in Pueblo, Colorado, licensed to practice law. I've been in Pueblo for many years. I'm a graduate of the University of Colorado Boulder Law School. My area that I practice mostly in is elder law, estate planning, guardianships, conservatorships, will contests, and similar to that. Today, I'm going to give you some ideas on the necessity for estate planning and other matters that come up during our lifetime in this very complex world that we live in. And I'm sure many of you know that a will is usually the starting point that we talk about for estate planning. Now, in Colorado, you have to be 18 years of age or older in order to sign a will. And basically, the will is a method, an easy method of giving instructions to your personal representative when you die on how to pay your bills and distribute your property. Now, Colorado uses the word personal representative for the person that you want to be in charge of your estate after you die. In the years past, and some states still use the word executor if it's a man, or executrix. Colorado went gender neutral, and so now personal representative is the word that we use. A will basically is a pretty simple document where you set forth information on how you want to leave your property when you die, and who you want to be in charge of making sure your wishes are granted. Now, there are certain laws in Colorado that govern wills, and Colorado is a pretty lenient state as to when you can sign a piece of paper on your own or when you have witnesses, etc. But the idea is the person who makes the will has to sign, and if you do not sign, then the will is usually ruled invalid. But as a lawyer, we try to always encourage you to sign your will before a notary and two witnesses. And that is what is called self-proving will, meaning that when you sign your will and you have two witnesses and it's notarized, then you don't have to call witnesses after your death to prove that really this is the will. Now, Colorado, as I mentioned, allows you to sign a piece of paper and just simply have it notarized, but sometimes questions arise because you don't have witnesses, and it may require a little testimony to show that you fully understood what you were signing. And there are also situations where you can sign a piece of paper and you may not have a notary present, but it is your signature, and it can be shown to be your signature. Now, the best way, of course, is to, in my opinion, have witnesses. But if you don't have witnesses and you're in a situation that you want to write out your wishes, then you do that. Okay, now Colorado has certain laws that say when you sign a will, you're supposed to have mental competency to understand the nature of what you're signing. And so that basically means giving information on who you are, your date of birth, understanding what assets you have, understanding your family, and how you want to leave your property. And if you lack that ability, it's sometimes challenged based upon the mental competency to make a will. Now, there are other things you're to make a will without someone unduly influencing you to write out your wishes for your last will. Now, a lot of times people may try to take advantage of the elderly person, and if they, especially if they have a will that was made years ago, and then they get older and they have other individuals who influence them to make a different will, then questions can sometimes arise as to whether the will was under undue influence. And in my practice, usually what I do is, and I've had clients for many, many years, and I go through a list of questions, making sure that their will is free and voluntary. Now, Colorado does allow a error, and in the legal jargon, we call it devisee. That is the person who's going to receive property to be a witness to a will. And but generally, that's a family member, such as husband and wife, or a child of the person making the will. So that's not something that's against Colorado law. But when a person comes to me and they are in their late 80s or 90s, and they want to change their will, and they want to leave their property to someone different than they wanted to during most of their life, then that raises a red flag. And so I usually ask them if they will consult a psychologist or somebody else to see if they are fully aware of what they're doing. And this doesn't happen too often, to be honest, but it does occasionally occur. And so that's something that we're aware of as practicing lawyers. Now, in Colorado, when a person doesn't make a will, essentially their property is distributed according to the rules of intestacy, or the law of intestacy. Now, intestacy basically means that you don't have a will, or some of the assets that were not mentioned in the will were not distributed. And so you have to follow the rules in Colorado as to what the law of intestacy is. Now, we always start off with who are the surviving individuals, heirs, when they die. When there's no will and you're entitled to property, you're called an heir. As I mentioned, when there is a will and you're entitled to property mentioned in the will, you're called a devisee. But getting to the idea of the no will situation, one of the first things that always comes up is who are your surviving heirs, and you look to see if there's a surviving spouse. Now, surviving spouses have certain rights that other heirs do not have. And in Colorado, you cannot disinherit a spouse unless you have what is called a prenuptial or a postnuptial agreement. So the first thing you do is you look to see if there's a surviving spouse. And then if there is a surviving spouse, you look to see if there's children, and you look to see if the children are the same children of the surviving spouse and the decedent. If they're not, it changes what your inheritance rights are. So if you're a surviving spouse and there's no will, you look to see what the family structure is, and you also look to see if your parents might be alive. And if you have no children, you look to see if a parent is alive, and then if there's no parent, then you look to see who your brothers and sisters are. And Colorado has a very detailed law on how property passes when you don't have a will. And the other thing is when you don't have a will and there are heirs, you look to see who's going to be in charge. And basically, the heirs have to agree who's going to be in charge. And if they can't agree, then you have to go to court and basically decide who is going to be in charge and be the personal representative to carry out the laws of intestacy. Okay, now essentially there are some situations where even if there is a will, that perhaps the personal representative is not following the laws of Colorado. Now, there are strict laws in Colorado on what a personal representative's responsibilities are. And if you fail to follow these laws, you can be held for breach of fiduciary duty and basically be responsible to the heirs for breaching that duty. So it's usually very important to understand that when you take on that responsibility, you have to follow the laws of Colorado to make sure that the wishes or if it's not a will, the intestacy laws are followed. Sometimes there are will disputes, and most will disputes center around whether the person was under undue influence or whether the person had the mental capacity to make a will. Those situations don't occur very often, but they do occur. Now, there's other situations where, and it's usually situations of maybe a second marriage or another marriage, and basically you have children from a prior marriage where you might think that you can just pass the assets to the children and not your surviving spouse. But there are laws that basically state that a surviving spouse is entitled to certain inheritance rights. And sometimes, although very seldom, but sometimes assets are transferred to someone other than the spouse, and there are laws to protect that spouse and look to see exactly what has taken place. So the whole point that I'm making about all of this is that the will that you're drawing, if you draw a will or sign a will, helps understand what's going on after your death. If you don't do that, then it opens up some questions. Now let me switch to situations where if there is no real estate, say for example, if a surviving spouse and real estate that she owns with the other spouse or he owns with the other spouse is basically in joint tenancy, that passes outside of the will and goes to the surviving spouse. Then you look to see if, in fact, there are other assets and what the value of those assets are. And so in Colorado, if there is no real estate and the value of the other assets that will be passing are $70,000 or less, you can do the transfers by what is called affidavit for collection of small estates. And that happens to be on in a lot of husband and wife situations where the surviving spouse has mostly received the property through joint tenancy, but there might be a few things such as the car title that needs to be transferred. So when you do it by affidavit, you don't go through the court system. There's a document called affidavit for collections, and you sign that document, and you could have access to bank accounts, car titles, or other personal property. And that's designed so that you don't always have to go through the court system in order to transfer titles once the individual passes. Now, that can sometimes lead to conflicts, and sometimes you have to go to court to resolve that, but the idea in most cases is to make it less expensive. Now, if you have mostly joint tenancy property and you don't have to do any probate of the will through the court system, nonetheless, the original will is supposed to go to the court system probate clerk within 10 days after death. Now, not too many people know about that law except for lawyers and a few other people, but the idea is to protect the value of making a will. And again, the value of making a will is that it cuts down on a lot of conflict and makes it easier to pass property of the deceased person. Now, other types of methods of transferring property are you can create a trust, and you can do that during your lifetime, and it can either be revocable or it can be irrevocable. Now, most trusts are revocable because if the property in a trust and it's for your benefit and you might want to change your mind, you do it revocable. In fact, the law is it's presumed to be revocable unless you specifically say it's irrevocable. And sometimes in tax situations, you might make it irrevocable so that you can receive the tax benefits. Or if there's family situation where after you die, you want the trust to be irrevocable, you can do that. But the value of a trust is you look to see what the future might be in store for yourself. And if you have property in several states, a trust is very advantageous. If you have a disability where you may need someone to help manage your assets, and then they're in the trust, and so you have a trustee do that. And then upon your death, you set forth how you want the property in the trust to be distributed. Now, there's kind of a misconception that if you create a trust, it's much cheaper than if you don't have an estate. And sometimes that's true, but a lot of times it isn't, because if you appoint a trustee, they're not a family member, and they are entitled to be compensated, and they have to follow the rules of the trust. It can be just as complex as an estate. The other part about being in a trust is that you have to feel comfortable that the assets in the trust are titled in the trust name, not in your name. And I've had clients where we've created trusts because they go to a seminar perhaps and they hear about creating these revocable living trusts, and you avoid probate. But then you discover that the paperwork that is required to keep the trust going during your lifetime is somewhat complex. And I've had clients who've actually created trusts and then they got fed up with doing all the paperwork, and so they've gone back to their own names. Now, the other part of estate planning is that you never know when you're not going to be able to do things for yourself. And so Colorado has both medical and financial power of attorneys. And this basically is a document where you usually entrust someone that you have great confidence in to help you when you're not able to do it. For example, if you suffer a stroke and you're not able to pay your bills, or you have a little difficulty in understanding, you designate someone, and it's usually that you're close to and you have trust in, to make sure that they follow what is in your best interest. Now, Colorado is very strict on someone who is an agent under a power of attorney trying to take advantage of the individual. And not only can you be held civilly liable and have to give any property back, but you can also be criminally prosecuted. And the idea is to use agents under a power of attorney to make it easier for you when you face these difficult situations during your lifetime. Now, if you don't do any planning and you suffer situations where you need help and assistance, you can turn to the courts, and they have what are called the guardianship and the conservatorship actions in the courtroom. And basically, those are ways to manage your finances, or if it's a medical difficulty, you manage your medical situation by having the court appoint someone to be your guardian or your conservator. And essentially, that's a more complex situation than power of attorneys. And that doesn't mean that there's anything wrong with that. But it's just that basically it's more complex, and you have reporting requirements that you have to follow. And you're under careful scrutiny to make sure you are doing what you're supposed to be doing for the person's assets, or if it's a medical situation, for the medical situation. Now, the other issues that sometimes come up during our lifetime, if you have a debilitating illness, the question comes up about making a living will. Now, living will is a term that most lay people have adopted to describe what is called a declaration regarding medical or surgical treatment. In Colorado, essentially, a living will says that if two doctors declare that you are either in a terminal condition or in a persistent vegetative state, then you can, and you no longer have the ability to accept or reject medical care, then you can give directions that you don't want to prolong your life by using artificial methods such as machines or feeding tubes. And again, that is a law in Colorado. It's taken several years, over a period of time, to do that. But it's very strict that if those are your wishes, they must be followed. And a lot of my clients do want to have a living will. such that it's limited to terminal or persistent vegetative state, and they don't want to prolong their lives through artificial means. Now, there are other planning devices when you have medical problems, and many of my clients are aware of these. One is a do not resuscitate document. Now, that ironically cannot be obtained through a lawyer's office. You have to get that from your doctor. But it's usually situations where you have a serious medical problem, gone through difficult times, and you don't want to continue using extraordinary measures. And the most common example is if you've had heart attacks and you are at home and the ambulance arrives and you don't want your heart shot back into rhythm, then you have this do not resuscitate directive. And almost all hospitals, when you go to the hospital, if you're elderly especially, they want to know if you have a do not resuscitate document. The other document that sometimes used, and again, you obtain it from your doctor, you can't obtain it from a lawyer, is extent of medical care. And so there's a document called extent of medical care. And some of my clients who have had chemotherapy, they basically use these documents to say, okay, if my cancer has returned, I don't want to have chemotherapy. And so they make that decision clear. And I've had other clients who've had transplants, and if the situation reoccurs, they do not want to have another transplant, and they write that out. So the idea is to plan for any eventuality so that you can meet what you're facing in the most respectful way. There are other methods, of course, besides a will or a trust or using power of attorneys, and that is payable upon death beneficiaries. And there's two that are frequently used in Colorado now, and one is the beneficiary deed. If you have title to property, and instead of going to probate court, you want to have that property automatically go to your children or to another person, you can sign a beneficiary deed during your lifetime. You can change your mind and you can revoke it at any time, but you have to record it. And if you don't record it, then it's not valid. There are other payable upon death beneficiary designations, and most people are familiar with bank accounts. Most bank accounts offer payable upon death beneficiary opportunities. And so that's another way to transfer without going through probate proceedings. They also allow you for car titles to make that possible. So the idea is to usually try to sit down, preferably with someone who knows what they're talking about, and plan for the future and try to keep the expenses down. I believe Colorado is a very frugal state when it comes to what it costs to probate wills or other estate matters. I would like to spend the last few minutes just talking about planning for situations where perhaps you have to go into a nursing home and you may have to apply for Medicaid. Now, Medicaid is a special federal program operated in conjunction with the states, where an individual with certain qualifications can receive help and assistance, and usually nursing home care or other special needs care. And again, it depends upon your marital status, because if you're husband and wife, they have different rules than if you're single, and the amount of assets that you have. And one of the assets that is very important in Medicaid application if you're married is the family home, because they now allow over 5 before they would count that as a resource. That doesn't happen too often, obviously, because it's valuable to use the online Medicaid. And there are other rules, but it's very important because nursing home care is very expensive, and over and above Social Security usually runs around $6,000 to $7,000 a month. So you have to do some planning on that, and they have special rules about transfer of assets before you can even apply. Okay, that kind of is overview. My concluding remarks are think about what your life is like now, plan for the future, and especially plan when you're no longer alive.